Welcome back to Law Talk Moments, a legal program designed to help make the complex simple and to promote the practice of law, which I unapologetically consider to be a noble profession. My name is Rob Caprera, and I'm humbled to be your host again for this program. Today I'd like to speak out of my nearly 40 years of law practice with some comments and observations regarding the natural process of grieving after the death of a loved one and how best to interact with the family members after a death. As a probate practitioner, I have dealt with numerous individuals and families right after the death of a loved one, certainly not with the frequency or intensity of an undertaker or funeral director, but in a little different climate with a different emphasis. Whereas the funeral director's major task is to deal with the body in a respectful and appropriate way, my role has been to deal with the decedent's assets in a respectful and appropriate way. And this has not always been easy. It involves people with heightened emotions, physical stress, confusion, fear, anxiety, and motivations based upon undesirable qualities such as greed, avarice, anger, and spite. Today, I'm beginning a 3-part series that will hopefully help everyone navigate through this challenging time. Today, we will consider the fundamental concept of an inheritance. To be able to deal with this topic, you must recognize an indispensable concept. An inheritance is not a right, it's a privilege. No one owes you an inheritance. There is a bumper sticker that can be seen once in a while affixed to a large truck or RV or boat trailer or something significantly costly that says essentially, "I'm spending my child's inheritance." This is obviously a tongue-in-cheek, comical comment made by the asset owner to prove a point by emphasizing a falsity. That is, the RV or boat is not the child's asset. It's the parent's asset, and the parent has every right to do his or her things with his or her money. Rightly or wrongly, prudently or imprudently, it's the parent's money, and he or she can do whatever he or she pleases with it. The child has zero say in the matter because simply, it's not the child's money. When initially sitting down with a family after a death, oftentimes when we have the reading of the will, I make a point of the fact that any money or assets that they might wind up with when the estate is complete is not the fulfillment of a right they hold, but it's a fortunate occurrence for which they do not have a valid expectation. I have found that recalibrating a family's expectations in this way at the beginning lowers the level of greed and avarice and makes the family a lot easier to deal with in the long haul of the estate process. Dealing with reality is not always that difficult, but trying to manage a child's or client's inaccurate expectations or assumptions can be tricky for the inexperienced practitioner. If the cards can be laid out on the table right at the beginning, then the greatest chance for success and peace and harmony can be achieved. Experience is a great teacher, and I only wish I knew 30 years ago what I know now. Perhaps that's why I enjoy these Law Talk moments, so I can pass some of this information on to you and so that you can avoid needless heartaches and tension after the death of a loved one. For today's lesson, just remember, an inheritance is not a right, it's a privilege. Our time seems to be up for today. I look forward to our next time together with Law Talk Moments when we'll deal with people deep in the grieving process in part 2 of this series on navigating through the first weeks and months after a loved one dies. Please follow Law Talk Moments on www.capreralaw.com. And if you'd like your legal questions considered for future presentations, please submit them as well to www.capreralaw.com. As always, thank you for listening, and take care.